that the candidate insists that he should preside, if I understood Mr. Counsel for the applicant correctly.
No, he should not resign. That's paragraph 7.6, which was clearly denied in the answering affidavit. Even paragraph 7.6 in the founding affidavit doesn't say what was submitted to the court. It's the paragraph 7.6 of the founding affidavit, I think, what my lord is referring to.
My lord, what I intended to convey was that there may be a difference of interpretation. What does the word preside mean? And what we say is that if you look at what the president would do, he would be present when the military honors take place. He will be present when the funeral service is that's presided over by Bishop Banda, when that takes place, because he will receive the foreign heads of state. If that means he will preside, yes, then he presides. So it's an interpretation issue. They understand what they contend is that he shouldn't be there and he shouldn't use the word preside. What we say is he will do what FAA 7 says. That's what he will do. Nothing more, nothing less. May it please you, Lord.
As the court pleases, I've made the submissions on the conditional counterclaim. I don't know if there's any questions on that point. With regards to the striking out application of the applicants against certain portions of the answering affidavit, I'll be very quick. I do submit that at the very least, it's not really necessary to decide if it's vexatious or scandalous or irrelevant. They haven't showed any prejudice in those matters before court. With all due respect, it also doesn't really make sense because in that application they're blowing hot and cold. They seek to take out certain portions, but there are a lot of other portions that set out the facts in any event and deals with how the late president was treated by the current president. So in any event, the striking out application doesn't make a lot of sense because it still leaves in most of the evidence.
But those are facts that they could answer to.
My lady, I could answer to all the facts with all due respect. So when we say he was refused medical treatment and we attach a letter to the paper showing that he could not leave Zambia, they could say then obviously this is the reason for that. When he was refused to go to church, it's a factual event which they can answer to. Was he refused to go to church? If he was refused, what's the reason for that? Did they stop him from jogging? Is it true? And what's the reason for that? Did they open several criminal cases against his family? Is it true? Is there good reason for that? All of that they can answer to. There's no reason not to answer to it. The reason why it's in the application is not because it's irrelevant. It's to give context to this court in interpreting what the situation is between the parties and understanding the position of the respondent and why they feel so strongly about the material of the current president not having to do anything with the burial. So I would submit the striking application should be dismissed with cost, the same cost as what I'll argue or it should be cost in the court. With regards to the respondent's striking out application, there are certain passages in the replying affidavit that wants to, and stated as a fact, which is all hearsay, that the president wanted to be buried in Zambia. And I've listed those paragraphs. There's no evidence showing that he wanted to be buried in Zambia, and they cannot make that submission to the court, and this court can never find such a fact exists. Wherefore, those parts in our striking application is all hearsay and irrelevant and should be struck from the replying affidavit with all due respect. The last issue, which I will not belabor, I'll just submit, and the submission is already made in my heads of argument with regards to the ex parte order that was made by this court by the variation of the original court order and the conduct of the attorney for the applicant. The papers make it clear that she was aware of certain facts which she did not convey to the court. And under those circumstances, that instance needs to be referred to the LPC for further investigation. It should not transpire that any officer of this court, as court pleases, my lord.
Has that been done?
It is in our.
Complaint in,
No complaint has formally yet been lodged. We are a bit busy with this, but I take my lord's word. As the court pleases, like I say, I'm not going to take it further than what is said in the heads of argument. Then with regards to cost, we deal with cost also quite comprehensively in our heads of argument and set out the reasons why costs should be awarded on an attorney-client scale in favour of the respondents. If it's not on an attorney-client scale, I would submit that cost on a scale C would be appropriate, including obviously a cost of the employment of two counsel. The reason being the very serious nature of the application, that the respondent was forced to abandon a burial that was already planned, money already spent. It caused great embarrassment to the respondent and the family to having to cancel that burial on a very, very short notice. The original application, they say in the urgent application that they got notice on the 18th of June that the body will not be repatriated back to Zambia. That's correct. Then they ought to have brought it already on the 20th and not waited till the 25th on the day of the burial to bring such an application. It's an abuse of process and caused great distress, especially to the widow of the late president, and embarrassment because everybody was already sitting and present at the burial that was arranged for the 25th of June. The respondents, I just want to...
given regards to the nature of this matter, parties sit down, try to reach an amicable solution.
My lord,
So, I'm not yet done. There were costs that were incurred by the respondents and funeral assault. Wouldn't it be appropriate that the cost should make an order in each party to pay its own costs?
yeah, my lord, it's a very novel application. I understand what my lord's conveying, that it might be an option for this court under the circumstances dealing with the burial rights, and that there's not really, it seems, pertinent case law on this point yet. I can't take it further than that, except to say pocket for trying to...
Somehow, it might be there's a concession by the government that they should get benefits, should get a house, vehicle, and so on.
Well, my lord, unfortunately...
It's under oath.
Oh.
And the pension going forward.
My lord, unfortunately, I'm not in a position to say what's happening in Zambia and why, or anything at all with regard to, let's call it undertakings and whether they'll be kept or not kept, and I'm not going to venture into those grounds.
No, but my main question is, would it be appropriate for this court to make such an order?
About benefits then?
No, that
Well.
each party should be liable for its own costs in this application.
My lord, I don't think it would be appropriate. I don't think the respondent needs to be out of pocket, with all due respect, but I understand that it's a novel point.
Question? Then should we reply?
15 minutes, my lord. Firstly, I must just start with a correction. The Kutuane matter, I submitted or stated that that matter dealt with a civil law marriage. It's not